Bismillahirrahmanirrahim. Legal Eagles, welcome from Oxford. My name is Zubair Abbasi, and I head the Global Institute of Law, Oxford. Today, in our Legal Eagle session, we shall be joined by Mr. Ras Masood, Ras Nabil. Ras is our graduate from LUMS Law School. He will graduate this month, but the good news is that he is already admitted for his master's at both Oxford and Cambridge, and he has decided to join Cambridge. Our session will consist of two parts. During part one, Ras will talk about Islamic law and its interaction with international human rights law. And during second session, we shall have question and answers and also explore a little bit about Ras's journey as a student and as a scholar. So over to you, Ras, and welcome to our Legal Eagle session.
Thank you, Dr. Zubair. Assalamu alaikum, everyone. I'll just be sharing the presentation on the screen. Sir, can you please confirm if you can see the screen so I may begin? Sir, can you just confirm if you can see the screen?
Yes, I can see the screen, and I can see your slides. So please proceed, Ras.
All right. Okay. Hello and assalamu alaikum, everyone. My name is Ras Nabil, and I am a recent graduate from the Sheikh Ahmed Hassan School of Law at the Lahore University of Management Sciences. The topic for my presentation today is bridging the gaps between Islamic law and international human rights law. I actually presented on this topic for a course with Dr. Zubair Abbasi, and so it gives me great pleasure to be presenting on this topic to a wider audience today. To start off, it is well established that the intersection of Islamic law and human rights remains to be a contentious topic of debate in various international and domestic forums and has developed into a diverse field of Islamic legal academia, with various scholars having differing perspectives on the matter. Islamic law, or Sharia, is misconstrued often as being anti-rights. The predominant narrative, particularly in non-Muslim states, is that Sharia is a regressive set of norms that are inflexible, inhumane, and often rigid. On the flip side, international human rights law is often misconstrued as anti-religion, or particularly as incompatible with Islam, as it is not truly able to grasp the fact that Islamic law draws heavily upon the natural law tradition rather than a positive law tradition, which is why reform or flexibility is not an easy task. The debate between these two narratives has therefore arisen as to whether these two can actually be reconciled with each other. Different attitudes have arisen in scholarship as well as popular cultural narratives, which shall be the focus of this presentation. However, first, I believe it is pertinent to understand the philosophical underpinnings of both international human rights law and rights under Islamic law to determine the fundamental contentions between the two. So to start off with international human rights law, I'll be referring to international human rights law quite generally in this presentation. However, my primary focus will be on the Universal Declaration of Human Rights and other UN conventions. So these conventions draw upon the concept of rights from the Western liberal political philosophy tradition. Philosophers such as Thomas Hobbes, John Locke, and Jean-Jacques Rousseau emphasize upon the social contract theory, under which people agree to form a society by giving up certain powers to a sovereign authority. This society is created to essentially ensure that each person, each individual experiences true freedom, both individually and collectively as a society. And everyone is protected from the harms from other citizens as well as of the abuses of power by the sovereign. Thus, a rights system was essentially developed to act as a limitation upon uncontrolled sovereign power, thus prioritizing the protection of the individual. However, if we look at rights under Islamic law, we have to consider the fact that they are divided into two broad sets of rights. The first are the rights of God, or hukuk Allah, which refer to obligations that human beings have to God as their creator. These are largely faith-based, including prayer, fasting, charity, the Hajj pilgrimage, etc. The second would be the rights of the community, which refer to obligations that human beings owe to other human beings. However, it should be mentioned that this is irrespective of any human being's religious affiliation. Under Islamic law, the concept of sovereignty, if we're going to look at it in the positive law connotation, under Islamic law, sovereignty lies solely with God for matters that are within the rights of God. However, if we consider it within the social contract theory or a similar analogy within Islamic law, sovereignty over rights of the community are given over or relinquished to human beings. This demarcation of sovereignty does not necessarily tie in very easily with certain international human rights norms. For example, the freedom of religion falls under the rights of God, which means that there is very little that we as human beings can actually legitimately do about the right to religious freedom through positive legislation. Because the Quran is also recognized as God's word, it is not as easily flexible as human rights treaties, as the rights within Islamic law do have religious connotations. However, different principles have been developed under Islamic jurisprudence to allow for interpretive flexibility. Such tools include the Maqasid al-Shari or the principles of the Sharia, which allow for the creation of rules that are in conformity with Islamic principles, but not necessarily those that are conforming to a particular rule codified in the Quran or the Sunnah. Similarly, the doctrine of public interest, i.e., maslaha, allows for the creation of rules that are for the benefit of the public. Ultimately, rights under Islamic law strive to allow the individual and the community to strengthen and practice their Islamic faith while also ensuring civil relations amongst others, the latter being an important part of faith as well. I will now be talking about the four paradigms or overarching schools of thought that have developed in Islamic law and human rights scholarship, and by extension in popular discourse as well. The first is the secular model, which privileges a secular paradigm for rights, normally along the lines of international human rights as they are espoused in various conventions. The second is the apologist model, which privileges an Islamic conception of rights over secular models. The third is a critical post-colonial perspective on rights as a new form of Western imperialism. And finally is the Muslim reformist position, which tries to find points of continuity between Western legal and Muslim legal traditions. I will now be talking about these schools of thought in a bit more detail. So first, the secular model. This model views rights under Islamic law as inferior to the international human rights system. This is because it assumes that religious actors act less rationally than secular actors, thereby interfering with the fulfillment of human rights. The model also does not fully acknowledge the complexities of Islamic law, with the distinction between huququllah, or the rights of God, and huququl ibad, the rights of the community, and ignores the difficulty in dismissing religious instruction. It also does not adopt a historicized and contextual understanding of the Sharia as a holistic legal system which already provides for a right system that can be harmonized with rather than completely replaced by the international human rights system. Next is the Muslim apologist model. This model favors rights under Islamic law over international human rights, as it believes that the former are sufficient and perfect as instructed, and that international human rights law is essentially not necessary for Muslim states. However, much like the secular model, this model accepts a singular form of rights as provided for under a particular context in Islamic history, even though the application of this might be counterproductive to achieving the principles of Islam within contemporary society. Furthermore, historically speaking, Muslim apologism has given rise to human rights violations because certain rules are viewed as the word of God. This allows sovereign authorities to abuse their powers and bypass normal constitutional parameters of accountability, such as by torturing political prisoners. By viewing certain rules as the word of God, the flexibility of these rules are therefore limited, even though Islamic jurisprudence has developed to allow for interpretive flexibility to make certain rights or legal norms applicable to different states as per their individual requirements. The third model, the Marxist or post-colonial critique model, looks at international human rights law as a new form of Western ideological imperialism. It recognizes that the rights that make up the corpus of international human rights law have been largely drafted and enforced by those with global power and privilege, and do not necessarily take into account the lived experiences of other nation states, particularly the global south and Muslim majority states, which is why these rights are not necessarily universal in nature. However, this school of thought does not necessarily assert a solution or an alternative approach, but rather focuses on delegitimizing the entire prospect of international human rights law as a new form of colonialism. This could actually increase intolerance against human rights rather than facilitate its acceptance as a normative doctrine regardless of political motivation. Lastly, the Muslim reformist model attempts to find a middle ground between rights under Islamic law and international human rights law through a contextualized and contextual reading and understanding of the Sharia. This forms the basis for the harmonizing of international human rights principles with Islamic law. However, within this model, one must be wary of how much reform is actually permitted within the bounds of religious dogma, as unauthorized attempts at reform might stray too far from religious instruction. Furthermore, reformism is difficult in practice because those with religious conviction may resist the idea of even accepting that reform is possible, which prevents the harmonization process altogether. I will now be talking about the history of how this divide between international human rights law and Islamic law began and its progress over the years. So, delegates of Muslim states had a very active participatory role in the drafting process of the Universal Declaration of Human Rights, the UDHR. However, despite their active participation, some delegates, namely Jamil Baroudi, who represented Saudi Arabia at the time, raised contentions about the listed rights on the screen. In this presentation, I will focus my discussion on the various paradigms mentioned in relation to the first two emboldened rights, religious freedom and gender equality. Because of these contentions, it was of no surprise that the UDHR and other UN treaties were not effectively being implemented in Muslim majority countries. Criticism was levied against Muslim majority countries as being anti rights, a narrative that we continue to see today. In response to this, the 1972 Charter of the Organization of the Islamic Conference, the OIC, drafted and signed the Cairo Declaration on Human Rights in 1993, which drew upon teachings from the Quran and Sunnah in its formulation of various rights. Some of the key articles within this document include Article 24 of the CDHR, which states that all enumerated rights are subject to the Sharia, and Article 25, which states that the Islamic Sharia is the only source of reference for the explanation or clarification of any of the declaration's articles. So we see a very clear influence of Sharia in informing both the formulation of these rights as well as their implementation, and how this differs from the previous UDHR. And this contrast will become clearer when I discuss the two rights in more specific detail. So, in response to this growing criticism of human rights, the drafting of the CDHR was also called into question by several scholars. Some argue that it was a response to a new form of Western ideological imperialism, which was reminiscent of the colonial experience of most Muslim majority states. Others stated that it was drafted to express disagreement with the UDHR and other UN treaties and to assert the superiority of Islamic legal principles. The most adverse criticism to this was that the CDHR espoused a performative tokenism of sorts, whereby Muslim states basically wanted to display a support and appreciation for human rights without actually having to be accountable for their implementation. And this is very clear by the fact that there were very clear human rights violation statistics that were apparent at the time of the entire drafting of the Cairo Declaration. So, in response to this growing criticism of human rights as Western ideological imperialism, reformists highlight how this can be counterproductive to actually enforcing human rights. Again, as stated before, by demonizing them, states may completely erase human rights from their political agendas. Reformists also argue that a perfect balance between the rights of the community and the rights of Allah is an unachievable and unrealistic ideal. Thus, reformists such as Abdullahi and Naeem argue for a distinction between Sharia as a basis for religious identity and spirituality on the one hand, and Sharia as a program for social and moral reform on the other. He argues that if we envision Sharia to be the former rather than the latter rather than the former, it will allow states to transition to a modern paradigm of law and governance that privileges human rights without compromising on the Islamicity of their enforcement. He also argues that certain interpretive tools exist, such as Maslaha and Maqasid al-Shari, which argue that the divine law has been ordained with the aim of benefiting humanity above all. Thus, divine law must be interpreted in a way that results in the greatest public benefit as long as this interpretation retains the essence of the principles of Islam. I will now move on to the discussion of two of the most contentious rights from the perspective of Islamic law and human rights. by contextualizing them within the four paradigms previously mentioned. The first is the freedom of religion. So I have basically duplicated the two relevant articles on the screen, one from the UDHR and one from the CDHR. Notice the difference in the drafting of Article 18 of the UDHR and Article 10 of the CDHR. The UDHR article allows for an expansive purview of the right to religious freedom, which espouses the right to convert and to manifest their religious belief. The prioritization of freedom falls in line with the Western liberal ideal of the individual above all. However, the Cairo Declaration right is related only to preventing forced conversion or apostasy, which emulates a freedom from coercion in matters of faith as per the Quran, but does not espouse the same extent of rights as the UDHR because Islamic law does not accept a Muslim's ability to convert to another religion. So, in terms of the right to religious freedom, if we look at the four paradigms, secularists would claim that the only way forward is a complete bifurcation of church and state, a complete separation towards a secular model of state, which means complete secularism in order to protect the individual's right to religious belief and conversion. Muslim apologetics, however, would claim that Islam already protects religious freedom as well as the rights of Christians and Jews. Thus, the religious freedom espoused under Islam is defined as freedom from coercion in matters of faith. However, scholars in this paradigm do not have a clear position on apostasy or blasphemy. Post-colonial or Marxist critiques would argue that the concept of religious freedom is quite contradictory to the West's colonial history, which was characterized by the sending of Christian missionaries to newfound colonies and forcefully converting them to Christianity. The fact that these Western countries now hold global power and have now normalized a church-state separation is testament to this ideological neo-imperialism, which is why this conception of religious freedom is absurd and inconsistent with Islam. However, reformists claim that there will be a certain degree of church state separation needed to protect the interests of religious minorities. While this position may be similar to the secularists, the reformists do not advocate for a complete separation of church and state. Rather, they advocate for a gradual depoliticization of Islam, particularly radical Islam, right wing Islam, because a modern pluralist state must prioritize the rights of the individual, and that a state prioritizing the rights of God is no longer a required state structure 1400 years after the advent of Islam. Moving on to gender equality now, the UDHR article espouses a clear non discrimination and equality clause in Article 1, as well as a protection of marital rights under Article 16, subarticle 1. However, the Cairo Declaration explicitly defines the rights of women as being distinct from those of men, and it recognizes the equality of women and men insofar as human dignity is concerned. The provision of marital rights does not mention anything on rights during marriage and upon its dissolution, in contrast to the UDHR provision. Apologies for the slide, I believe there's a bit of a technical glitch. Um, Secularists would argue that Islamic law is inherently hostile to women, which is why Muslim states must implement a gender equality that is espoused under international treaties. However, Muslim apologetics, much like the CDHR provision, claim that Islam already provides women with a significant amount of rights, and this is a position that predates gender equality in the West. This was evident in Egypt's reservations to the CEDAW, claiming that Islam has already liberated women. Post-colonial critics, however, would claim that Western feminism wrongly assumes the similarity of experiences of women in Muslim countries, which is why the gender equality that is espoused in international human rights law is inapplicable. Reformists would claim that that it is necessary to reinterpret Islamic scriptures and work towards reforming legal practices to ensure gender equality in Muslim countries, as this is a key principle of Islam. An example of an organization that adopts this approach is Musawa, which is an Egyptian female-led NGO that reinterprets Islamic scriptures and legal practices to encourage Muslim states to ratify CEDAW and other similar treaties. After delving into this analysis, the following question naturally arises. What is the way forward? Of course, all these various perspectives do have their respective credibility. But now we must consider the practical reality of these contentions. With Islam and human rights being pitted against each other in the popular narrative and political narratives, the most pragmatic step is to work towards reconciling these contentions to appease both sides of the debate. In my opinion, The most effective school of thought would be the reformist perspective. So, in line with that, again, apologies for that. Um, In line with this, we must consider the fact that international human rights are not universally applicable. Because the concept of a human right is a normative one and each nation state has its own normative values, the human rights framework in each state will not be the same. Therefore, such frameworks need to be adapted to each state's own social, political, cultural, and economic circumstances. Similarly, Islamic rights need to be understood in a way that recognizes that certain instructions in the Quran and Sunnah were context specific to Arabia 1400 years ago. Islam, as a religion and as a moral and ethical code, was designed specifically to evolve and continue to be applicable in all temporal and spatial contexts, which is why emphasis needs to be placed on contextualized interpretation of its instructions. We must also recognize that law and governance has significantly evolved into a much more complex system than what it was at the time that the Quran was revealed, which is why there is a need for more complex legislation, policy making, and jurisprudence in general. We must also recognize that with political power comes the power to eliminate voices from political discourse, specifically those of minority groups. Minority groups require specific protection from the tyranny of the majority, which often leads to human rights violations. The suppression of such voices is amongst the first steps to perpetuate such violations. Therefore, it is imperative to encourage the participation of all voices on matters of human rights, particularly from different perspectives, in order to reach an ultimate solution that is viable for all parties involved in human rights legislation, policy, and implementation. What we're seeing today, particularly in Pakistan and other countries in the region, is the role of religion in the law and in governance. While there's nothing fundamentally wrong with religious states, religion is often used to suppress minority voices and to legitimize the arbitrary use of coercive violence by the state. Thus, to prioritize a discourse on human rights, it is imperative to depoliticize religion. By this, I do not necessarily mean that all states need to be secular, but that the state must be able to recognize the dangers of politically charged right wing religious fundamentalist groups. The motivations of such groups brings upon the superiority of one religion over the other, which fuels anti minority rhetoric and violence. It is also these groups who then predominantly villainize any discussion on human rights in the first place. That is why we must collectively acknowledge the fact that this is not an easy task. The prioritization of human rights is something that is much easier said than done. An immediate upheaval of the current understanding of human rights discourse, particularly in this region of the world, is an unrealistic ideal bordering European. That is why a slow, progressive change is the way forward, particularly where opposition to human rights is combined with religious fervor. It is therefore imperative to engage in internal discourses with the framework of religious communities to understand their reservations. We must also encourage context specific interpretation and revision of Islamic teachings to prioritize the betterment of individuals within society rather than prioritizing the politicized assertion of one true Islam, because the latter would give rise to intolerance, violence, and human rights violations, all of which actually contradict the very fundamental notions of Islam. Again, this is not going to be an easy task, which is why we must strive towards small progressive steps, which will eventually culminate in greater respect for human rights within Islamic legal frameworks around the world. That is it. Thank you so much. I am now open for questions.
Thank you very much for your excellent presentation, Ross. That was wonderful. I think we want to take a short break of 10 minutes. So let our audience absorb whatever you have given us. And meanwhile, I see that lots of people are engaged on Facebook. They're asking their questions. So we'll take a short break of about 10 minutes, and then we'll take you live on Facebook again. So
Great.
let's have a short break, and then we are coming back. All right.